Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legalistening, where you can unlock some fun bonus content with me, Zach, and some special guests. Thanks so much for all your support. Hey, welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey there, just me today. I'm about to bring you the dissenting opinion of Justice Cote in Callow and Zollinger. If you want to hear what me and Zach thought about the case and a little bit of frame of reference, head on over to the majority's decision. Enjoy! The following are the reasons delivered by Justice Cote. What constitutes actively misleading conduct in the context of a contractual right to terminate without cause? Where should the line be drawn between active dishonesty and permissible non-disclosure of information relevant to termination? Does a party to a contract have an obligation to dissuade his counterparty from entertaining hopes regarding the duration of their business relationship? These are the questions raised by this appeal. In this case, the respondents, Baycrest, bargained for a right to terminate at any time and for any other reason than unsatisfactory services upon giving 10 days' notice. Baycrest made the decision to terminate, but it chose to wait before sending the notice as it did not want to jeopardize the performance of other work that was being done by the appellant, Callow. In the meantime, Baycrest became aware that its counterparty was entertaining hopes of a renewal. Although it did not say or do anything that materially contributed to those hopes. Baycrest did nothing to discourage them. Such conduct may not be laudable, but it does not fall within the category of active dishonesty prohibited by the contractual duty of honest performance. Part 1. Issue on appeal. Both of my colleagues seem to agree on the following propositions. First, the case concerns solely the duty of honest performance and not the duty to exercise discretionary powers in good faith. Second, the duty of honest performance means simply that parties must not lie or otherwise knowingly mislead each other about matters directly linked to the performance of the contract. Third, there is no duty to disclose information or one's intentions with respect to termination. Fourth, there is no need to extend the law by recognizing a new duty of good faith relating to active non-disclosure. I take it we all agree with these premises. Therefore, the issue, when properly framed, bears on the distinction referred to in Bassin between actively misleading conduct and permissible non-disclosure. In the context of this case, it comes down to this. Did Baycrest lie or otherwise knowingly mislead Callow into thinking that there was no risk it would exercise its right to terminate the winter agreement for any other reason than unsatisfactory services? The answer to this question is no. Before turning to my analysis, I wish to express my substantial agreement with Justice Brown's observations, insofar as they pertain to the role of external legal concepts. Justice Kazure states at paragraph 44 of his reasons that no expansion of the law set forth in Bassin is necessary to dispose of this appeal. However, he then embarks on, and I say this respectfully, an unnecessary comparative exercise between the civil law and the common law under the pretext of a dialogue. I am perplexed by the virtues of dialogue in a case like this one where no gaps in the common law need to be filled and no rules need to be modified. I do not see why we should adopt such an approach, one that provides no palpable benefits, that is also arbitrary and unpredictable. That being said, I believe that the common law as it now stands does not support the result my colleagues arrive at. I am afraid that the unnecessary debate about comparative legal exercises may have diverted attention from the facts of this case as they are. Part 2. Ambit of the duty of honest performance. Subpart A. Context in which the duty was created. In Bassin, the court unanimously introduced the contractual duty of honest performance as a new common law duty under the broad umbrella of the organizing principle of good faith performance of contracts. Justice Cromwell stressed that this was no more than a modest incremental step, with the duty of honest performance being a minimum standard. In Justice Cromwell's opinion, the new duty would interfere very little with the freedom of contract, so little that he thought such interference would be more theoretical than real. On the subject of the organizing principle of good faith, from which it grew, Justice Cromwell stated, quote, "The principle of good faith must be applied in a manner that is consistent with the fundamental commitments of the common law of contract, which generally places great weight on the freedom of contracting parties to pursue their individual self-interest. In commerce, a party may sometimes cause loss to another, even intentionally, in the legitimate pursuit of economic self-interest. The development of the principle of good faith must be clear to not veer into a form of ad hoc judicial moralism or palm tree justice. In particular, the organizing principle of good faith should not be used as a pretext for scrutinizing the motives of contracting parties." End quote. Justice Cromwell also expressed specific concerns relating to the clarity of the duty, its effect on commercial certainty, and other practical implications. He endeavored to explain what the new duty was not. Quote, "The duty of honest performance that I propose should not be confused with the duty of disclosure or fiduciary loyalty. A party to a contract has no general duty to subordinate his or her interest to that of the other party." End quote. Turning to a positive description, he stressed that the duty of honest performance was a simple requirement not to lie or knowingly mislead about matters directly linked to performance of the contract. The requirement that parties not lie is straightforward, but what kind of conduct is covered by the requirement that they not otherwise knowingly mislead each other? Absent a duty to disclose, it is far from obvious when exactly one's silence will knowingly mislead the other contracting party. Are we to draw sophisticated distinctions between mere silence and other types of silence, as Justice Brown suggests? If that be so, I wonder how a contracting party, on whom I note the law imposes neither a duty of loyalty or of disclosure, nor a requirement to forego advantages flowing from the contract, is supposed to know at what point a permissible silence turns into a non-permissible silence that may constitute a breach of contract. With the greatest respect, I do not believe that such casuistry is compatible with the simple requirement Justice Cromwell meant to set out in Basson. As Justice Cromwell put it, a clear distinction can be drawn between a failure to disclose a material fact, even a firm intention to end the contractual arrangement, and active dishonesty. He added that United Roasters makes it clear that there is no unilateral duty to disclose information relevant to termination. But the situation is quite different, as I see it, when it comes to actively misleading or deceiving the other contracting party in relation to performance of the contract. These words should be taken at face value. The duty of honest performance should remain clear and easy to apply. Subpart B. Permissible Non-Disclosure. It must be borne in mind that all obligations flowing from the duty of honest performance are negative obligations. Extending the duty beyond that scope would detract from certainty in commercial dealings. Therefore, silence cannot be considered dishonest within the meaning of Basson unless there is a positive obligation to speak. Such an obligation does not arise simply because a party to a contract realizes that his counterparty is operating under a mistaken belief. Absent a duty of disclosure, that is, absent any kind of freestanding positive obligation flowing from the duty of honest performance, a party to a contract has no obligation to correct his counterparty's mistaken belief unless the party's active conduct has materially contributed to it. What constitutes a material contribution will obviously depend upon the context, which includes the nature of the party's relationship, as well as the relevant provisions of the contract. But the reason underlying this requirement is a practical one that is consistent with Basson's emphasis on commercial expectations. Parties that prefer not to disclose certain information, which they are entitled not to do, are not required to adopt a new line of conduct in their contractual relationship simply because they choose silence over speech. It cannot be that the law, on the one hand, allows contracting parties not to disclose information, but, on the other hand, negates that possibility by imposing a standard of conduct that is at odds with the spontaneous attitudes, such as evasiveness and equivocation, parties might have when their conversations bear precisely on what they wish not to disclose. Even though parties who make that choice must be careful with what they say or do, especially if they become aware that their counterparties are operating under a mistaken belief, They should not be asked to behave as if their actions were being scrutinized under a microscope to determine whether they have contributed to that mistaken belief. Such a requirement would be unacceptable. In the context of a right to terminate a contract without cause, a party that intends to end an agreement does not have to convey hints in order to alert his counterparty that their business relationship is in danger. No duty of disclosure should mean no duty of disclosure. A party's awareness of his counterparty's mistaken belief will therefore not, in itself, trigger an obligation to speak unless the party has taken positive action that materially contributed to that belief. The act of conduct and the mistaken belief must both pertain to contractual performance. Otherwise, it could hardly be said that one has knowingly misled the other about matters directly linked to the performance of the contract. In sum, the minimum standard of honesty imposed by the duty of honest performance has to be consistent with the other principles set out in Dissent. It also has to be realistic and not overly formalistic. Absent a duty of disclosure, a party has no obligation to dissuade his counterparty from persisting in a mistaken belief. This does not mean that the party may induce or reinforce such a belief by significant positive actions or representations. There is an obligation to correct this mistaken belief if the party's act of conduct has materially contributed to it. Part 3. Analysis. Callow and Baycrest entered into two 2-year contracts, a winter agreement covering mostly snow removal services for the period from November 1st, 2012 to April 30th, 2014, and a summer maintenance services agreement for the period from May 1st, 2012 to October 31st, 2013. The winter agreement, which is at issue here, contained the following provision. 9. If the contractor, i.e. Callow, fails to give satisfactory service to the corporation, i.e. Baycrest, in accordance with the terms of this agreement and the specifications and general conditions attached hereto, or if for any other reason the contractor's services are no longer required for the whole or part of the property covered by this agreement, then the corporation may terminate this contract upon giving 10 days' notice in writing to the contractor, and upon such termination, all obligations of the contractor shall cease, and the corporation shall pay to the contractor any monies due to it up to the date of such terminations. In March or April 2013, Baycrest decided to terminate the winter agreement. On September 12, 2013, it gave Callow 10 days' notice that it was terminating the contract. In the meantime, Baycrest had learned that Callow was performing free extra landscaping work and that he was under the impression the winter agreement would not be terminated. It can easily be understood from these circumstances that Callow was shocked by the termination. Callow believed that if there was a problem, he would have expected Baycrest to bring it to his attention like it had done in the past. Baycrest's behavior was certainly discourteous and cavalier. Yet that is not the question here. The question is whether Baycrest materially contributed to Callow's mistaken belief that the contract would not be terminated. If Baycrest did, then it had an obligation to correct that mistaken belief in accordance with its duty of honest performance. Otherwise, it had no obligation to disclose anything. Before our court, Callow acknowledged that by entering into the winter agreement, he had taken the risk that Baycrest may terminate the contract but only disclose the termination decision on 10 days' written notice. I am of the view that according to the terms of the winter agreement, Callow could have found himself in the exact same situation regardless of Baycrest's behavior during the spring and summer of 2013. Such a possibility was in fact inherent in the contract he had bargained for. Callow essentially submits that Baycrest's act of conduct led him to believe that the winter agreement was no longer at risk of being terminated, despite the clear wording of the termination provision. He stresses the following points. 1. Baycrest deliberately kept its decision secret because it did not want to jeopardize the performance of the summer agreement. 2. Baycrest showed satisfaction with Callow's services. 3. Callow had discussions with Mr. Piexoto and Mr. Campbell regarding the renewal of the winter agreement. 4. Baycrest accepted Callow's freebie work. And 5. Baycrest was aware of Callow's mistaken belief. In my view, the appeal should be dismissed. The trial judge's understanding of active dishonesty is tainted by an error of law. She did not consider the principle that, in order to amount to a breach of the duty of honest performance, any act of dishonesty had to be directly linked to the performance of the contract. In assessing Baycrest's conduct, she did not inquire into whether Baycrest had lied or otherwise knowingly misled Callow about the exercise of its right to terminate the winter agreement for any other reason than unsatisfactory services. This explains why she wrongly insisted on, amongst other things, the need to address the alleged performance issues, despite the fact that the winter agreement could be terminated even if Callow's services were satisfactory. Furthermore, although the trial judge seems to have been aware that there was no duty of disclosure, she nonetheless found that Baycrest had acted in bad faith by withholding the information to ensure Callow performed the summer maintenance services contract. She never asked herself whether Baycrest had explicitly or implicitly said or done anything that could have misled Callow into thinking that the contract was at no risk of being terminated for any other reason than unsatisfactory services. It is clear from reading the trial judge's reasons as a whole that the representations she found had been made by Baycrest were not directly linked to the performance of the winter agreement. In sum, the trial judge's misunderstandings of the applicable legal principles vitiated the fact-finding process. Baycrest had bargained for a right to terminate its winter agreement for any reason and at any time upon giving 10 days' notice. Its duty of honest performance did not require it to forego this undeniable advantage flowing from the contract. It had no obligation to tell Callow about its decision to terminate the winter agreement until 10 days before the termination was to take effect, as the contract stipulated. Even after Baycrest became aware of Callow's mistaken belief, it had no obligation to refuse the freebie work Callow was performing on his own initiative or to correct this mistaken belief he was operating under. Such an obligation would have arisen only if Baycrest had contributed materially to that mistaken belief, by inducing it or reinforcing it. In light of the evidence and the trial judge's findings, I am not convinced that Baycrest has done so. I do not have the same reading as my colleague Justice Cazurer about certain of the trial judge's findings of fact. These findings expressed in very broad terms should not be insulated from the reasons as a whole and from the evidence that was before the trial judge. For instance, my colleague writes that Mr. Piexoto made statements to Mr. Callow suggesting that a renewal of the winter maintenance agreement was unlikely, and he considers that to be a key finding. However, the trial judge's finding pertained to what Callow had thought, not to what Baycrest had said, which is something quite different. Indeed, as I demonstrate below, the evidence supporting this key finding shows that Callow's thoughts regarding a renewal of the winter agreement had nothing to do with what Baycrest said to him. I now turn to the application of the foregoing legal principles to the facts of this case. Subpart A. Discussions about renewal. Callow argues that Baycrest materially contributed to his mistaken belief by discussing a possible renewal. Indeed, the renewal issue is central to this appeal. It is not disputed that unlike the contract at issue in Bassin, the winter agreement did not contemplate any automatic renewal. It only contemplated termination. Since renewal was not a term of the winter agreement, it cannot be considered performance of the contract within the meaning of Bassin. For Callow's claim to succeed, any breach of the duty of honest performance must pertain to termination. Both of my colleagues accept Callow's submission that it can be inferred from the discussions about renewal that the winter agreement was not in danger of termination. I would agree with such a proposition in the following circumstances. If one party leads another to believe that their contract will be renewed, it follows that the other party can reasonably expect their business relationship to be extended rather than terminated. But an inference to that effect cannot be drawn in the abstract. In order to infer that one party, through discussions about renewal, led the other party to think that there was no risk their existing agreement would be terminated, the inference-drawing process must obviously take into account the nature of the risk at stake and what was actually communicated during those discussions. Otherwise, the inference would entail a palpable and overriding error that would be subject to appellate review. Here, Section 9 of the Winter Agreement contemplated that the agreement might be terminated, 1. for unsatisfactory services, or 2. for any other reason than unsatisfactory services. Did Baycrest, by discussing renewal, communicate anything that might have led Callow to believe there was no risk the winter agreement would be terminated for any other reason than unsatisfactory services? The trial judge described the discussions between the parties as follows. Quote, during the spring and summer of 2013, Callow performed regular weekly grass cutting, garbage pickup, and was in discussions with the condominium corporation's board members to renew the contract for the following summer and also for the winter maintenance service contract for a further 2 years. At this time, Callow had only contemplated year 1 of a 2-year contract. The contract was supposed to remain in place for the winter of 2013-2014. After his discussions with Mr. Piexoto and Mr. Campbell, Mr. Callow thought that he was likely to get a 2-year renewal of his winter maintenance services contract, and they were satisfied with his services. End quote. The trial judge, who found Callow to be credible, relied on the following part of his testimony. Question. Now is probably a good time to, tell me about these discussions. Let's hear what discussions you were having. Answer. Mostly with Joe Piexoto. We discussed it, and he said, yeah, it looks good. I'm sure they'll be up for it. Let me talk to them. Question. Up for what? Answer. A 2-year renewal. Question. All right. Anyone else? Answer. Kyle Campbell I ran into once or twice on site, and we had discussions as well, too. Question. Okay, and what was your impression I suppose you already answered. Answer. That I was likely going to be getting a 2-year renewal. There was no reason not to. They were satisfied with the service. They were happy with it. Apparently not much importance was attached to the renewal issues at trial. The amended statement of claim did not even address this issue. It instead focused on Baycrest's knowledge, Callow's freebie work, and the provision of satisfactory services. Even though the trial judge did consider renewal, I note that her findings in this regard bore on Callow's mistaken belief that the winter agreement was likely to be renewed. They did not bear on anything Baycrest actually did or said that would have misled Callow into that belief. What Callow thought is one thing. What Baycrest said or did is another. According to Callow himself, Mr. Piexoto did not propose anything on behalf of Baycrest. Mr. Piexoto's statement that, I'm sure they'll be up for it, let me talk to them, clearly meant that despite his favorable opinion, he was not the one making the decision and that Baycrest had not even considered the mere possibility of a renewal at this time. It certainly could not be inferred from this statement that a renewal was likely. Callow's testimony does not suggest that he was misled into believing that Baycrest was actually contemplating a renewal. Mr. Piexoto's response instead presupposes the contrary. Nor does it suggest that Baycrest did or said anything to negate the risk Callow took that his contract might be terminated for any other reason than unsatisfactory services. Indeed, Callow insisted that he had believed a renewal was likely because there was no reason not to. They were satisfied with the service. They were happy with it. In his examination for discovery, Callow had given the same reason for thinking his winter agreement would be renewed. That is, because there was no reason not to. He did not refer to his discussions with Mr. Piexoto or Mr. Campbell. When asked if anyone had told him that his contract would be renewed, he said he could not recall. The evidence does not establish that Mr. Piexoto or Mr. Campbell initiated the discussions about renewal. On the contrary, it suggests that Callow did. When cross-examined about his freebie work, Callow admitted that, although he was under the mistaken belief that his contract was likely to be renewed, he was in fact only hopeful that it would be. Nowhere in his testimony did he suggest that he had been given any information that could mislead him into believing that Baycrest was seriously contemplating a 2-year renewal instead of termination. The trial judge referred to active communications between March and April and September 12, 2013, which deceived Callow, and to representations in anticipation of the notice period. But those references must be read in light of the evidence and the reasons as a whole. Even though the trial judge made credibility findings against Mr. Piexoto and Mr. Campbell, and credibility findings in favor of Callow, The evidence pertaining to renewal supports only a very limited number of inferences regarding termination. At most, it can be said that Mr. Piexoto and Mr. Campbell did not dissuade Callow from entertaining hopes when they had a chance to do so. But, and most importantly, they did not suggest that Baycrest was actually contemplating a continuation of their business relationship. If that had been the case, then I would agree that it might have been justifiable to infer that Callow had been led to believe there was no risk that his existing contract would be terminated before its term. But that was simply not the case here. In my view, the trial judge did not infer from the discussions about renewal that Baycrest had done or said anything to negate the risk that the winter agreement would be terminated for any other reason than unsatisfactory services. Had she made such an inference, it would be subject to appellate review, as it would not be supported by the evidence. Given the context discussed above, Mr. Piexoto's and Mr. Campbell's vague and evasive declarations did not materially contribute to Callow's mistaken belief that would have required Baycrest to disclose additional information. Subpart B. Baycrest's satisfaction with Callow's services. The trial judge placed great importance on the fact that Callow's services had been satisfactory and that Baycrest's conduct had given him no reason to think otherwise. I note that there is no finding that Baycrest communicated any particular sign of satisfaction pertaining to the performance of the winter agreement past March 19, 2013. That being said, there is nothing dishonest about Baycrest terminating the winter agreement after showing its satisfaction with the quality of Callow's work. Further, the parties had explicitly contemplated that Baycrest could terminate the winter agreement, even if it was satisfied with Callow's performance, as the contract provided that Baycrest could exercise its termination rights for any other reason than unsatisfactory services. Thus, positive feedback about Callow's services cannot justify Callow's mistaken belief that the contract would not be terminated. Subpart C. Callow's mistaken belief that the winter agreement would remain in effect. The trial judge found that Baycrest had continued to represent that the contract was not in danger. This finding was essentially grounded on the overall signs of satisfaction communicated by Baycrest on its acceptance of the freebie work and on Callow's mistaken belief following the discussions pertaining to renewal. As I have already explained, nothing here required Baycrest to disclose its intent to terminate the winter agreement. What the trial judge did not find is also relevant. She did not find that Baycrest had decided to forego its right to terminate the winter agreement. She did not find that Baycrest had lied to Callow. She did not find that Baycrest had negated the risk taken by Callow and that his contract would be terminated for any other reason than unsatisfactory services. Lastly, she did not clearly indicate why Callow so firmly believed that the winter maintenance services contract would remain in place during the following winter. Callow's belief that there was no risk Baycrest would exercise its termination right was based on two things. First, on the positive feedback he had received regarding his services. In his words, Baycrest was happy with it. However, this is not very relevant in a context in which Baycrest could terminate the winter agreement for any other reason than unsatisfactory services. Second, and most importantly, Callow's mistaken belief was based on an erroneous interpretation of the winter agreement. At trial, Callow testified that he was aware of the termination clause, but that he thought the 2-year term made it unenforceable. Question. So in that letter, there is a statement that the termination was in breach of the agreement. So my question for you is, at that point in time, what was your understanding? Why was the termination in breach of the agreement? Answer. Because they asked me, and we entered into a 2-year agreement to provide services both summer and winter, and I did so at a reduced rate. I upheld my end of the bargain, which was to perform that work at the reduced rate. They, and which I might add, I was not paid for, the landscaping and the final aspect of it, they were supposed to pay me. They didn't do it, and I continued to fulfill my contractual obligations. I expected nothing less than the same from them. Question. So when you knew that the winter contract there was a termination clause. Answer. They had a clause written in there. I didn't believe it to be enforceable because we had a 2-year contract. That's the whole idea to a 2-year contract. You have a contract for 2 years. I provide my services for 2 years and they pay me for those services. Even though this was not the position he took in this court, Callow's uninformed interpretation of the termination provision casts an important light on the reason why he did not believe there was a risk the winter agreement would be terminated for any other reason than unsatisfactory services. The evidence does not suggest that Baycrest said or did anything that could have negated that risk, nor does it suggest that Baycrest had anything to do with Callow's erroneous interpretation of the termination provision. I am therefore of the view that Baycrest was not required to correct Callow's mistaken belief by disclosing information it decided not to disclose. Part 4. Conclusion. The trial judge erred in concluding that Baycrest had to address performance issues or provide prompt notice prior to termination. She did not inquire into whether Baycrest had made any representations that it had misled Callow into thinking Baycrest would not terminate the winter agreement for any other reason than unsatisfactory services. In my view, the trial judge extended the ambit of the duty of honest performance in a way that was not consistent with other principles set out in Basson. In sum, the narrow issue in this appeal comes down to this. Did Baycrest lie or otherwise knowingly mislead Callow into thinking that there was no risk it would exercise its right to terminate the winter agreement for any other reason than unsatisfactory services? There were no outright lies. Baycrest was aware of Callow's mistaken belief that his services would be required for the upcoming winter, but Baycrest never forewent the contractual advantage it had of being able to end the winter agreement at any time upon 10 days' notice. Nor did Baycrest say or do anything that materially contributed to Callow's mistaken belief that the winter agreement would not be terminated for any other reason than unsatisfactory services. Regardless of how its conduct is characterized, Baycrest had no obligation to correct Callow's mistaken belief. To be clear, the result I arrive at should not be interpreted as meaning that Baycrest's behavior was appropriate or that Callow has no recourse. It means that Callow's recourse cannot be based on a breach of the duty of honest performance. The trial judge did in fact find that Baycrest had been unjustly enriched by the freebie work, but she stated that Callow had not provided evidence of his expenses. That question exceeds the scope of this appeal, however. I would therefore dismiss the appeal. Appeal allowed with costs throughout.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.